Viewers, Home Office is completely wrong and incorrect to diffuse pre-settled status on dependency for dependent parent. Because recently I have seen a couple of clients, and it's happened to one of my clients as well. The Home Office refused a pre-settled application for pre-settled status on the of a parents on the ground that they're not dependent on a sponsor. Now, I was in court, I think last week, and might be my client is watching as well. I'll not tell the name of the client for confidential reason. And I refer immigration rules to the judge that under immigration rules appendix EU annex 1 definition dependent parent clearly said in paragraph B and C. I'll show you in the screen what is said. Paragraph B said, unless C apply, the general rule is the parents has to be dependent. Okay, this is the general rule. But the exception of general rule is C. So if a parents enter in the UK on family permit, they will get visa for 3 years under EU settlement scheme. Bear in mind, and it is worth to mention that still parents can come and family member they can come under EU settlement scheme. So parents still can come under EU settlement scheme. Same requirement as EU law, EU regulations 7. So you are familiar with this. Now what happened now, once they get the family permit, they of course they need to prove dependency. Once they enter to the UK, and then they need to reapply for pre-settled status, because they got fast entry clearance for 6 months, and within 3 months they need to apply again for pre-settled status. Now once they are in the UK, Home Office now refusing parents' application for pre-settled status on the ground of dependency, because they are expecting that once parents are in the UK, they must continue to dependent on EU sponsor. But this is not. This is they don't require to dependent under immigration rules. Now, what actually happened? The Home Office caseworker, how anti-clearance officers misunderstood the immigration rules, and how they misunderstood. That was even I didn't understand what they misunderstood. But when I was attending in the court hearing, the Home Office lawyer was my opposite side, and when she making submission to the judge, to the tribunal, then I understand actually Home Office caseworker or the Home Office some legal representative even misunderstood the immigration rules, and accordingly they refused the pre-settled status. Now, how they misunderstood? Look at this screen. Right. So if you, this is the okay, let me come from the bit top, and then you will understand, okay, where this definition is said. So this is the appendix immigration rules, appendix EU. All right. So appendix EU. So if you go to the immigration rules, appendix EU, right? So immigration rules, appendix EU. So this is the appendix EU, and immigration rules. If you go to the definition section of yeah, this is the definition. No, not the definition section. I'll come back. So yeah, dependent, you see the dependent relatives, okay, but you need to look into the dependent parents. The next one will be dependent parents. Yeah, deportation. So dependent parents, right? So under immigration rule, appendix EU 14. So this is the immigration laws. Yeah, dependent parents. This is the definition parent. So you know the whole the appendix EU around 10-20 pages, but somewhere say only one line where the parents doesn't need to be dependent. But before I come here, let me explain you why Home Office caseworker misunderstood the immigration rules. So look at this first. Look at this immigration rules. So when my hearing start, so the Home Office said, Home Office refer, this is the definition where it say that paragraph B3, that the relevant sponsor or the spouse or civil partner at the date of application, unless the relevant sponsor is under 18 years, that dependency is assumed where the date of application is before 1st July 2021. Now, if someone make that means before 1st July 2021, the parents doesn't need to be proved dependency, but the law assume that they are dependent, right? However, if they make an application after 1st July 2021 on or onwards, according to this subparagraph, they have to be dependent. They have to be proof that they are dependent, and I'm agree with this. But there is an exception of these rules, right? And that exception, Home Office caseworker misunderstood. And under this exception, the parents doesn't need to be dependent. Now I'll show you where the exception is. But before that, so when submission start, the Home Office lawyer referred the judge that the application was made after 1st July 2021. Therefore, the assumption is not present. Accordingly, there has to be dependence. I refer the judge that if you look into the first line of the paragraph B, so look at this. Unless paragraph C immediately below apply. So B is a general rules that I agree they had the parents need to be dependent on sponsor, right? But the exception is unless C apply. What the C said? I think if you can give this argument, you will win your case. So C said this subparagraph apply, and the applicant therefore has to meet no requirement as to dependency. So C said if the applicant satisfies the following condition, Roman 1 or 2, they don't need to be dependent. So parents, they don't need to be dependent. What? And C said, furthermore, the applicant was previously granted limited leave to enter. The spot on key point. The applicant was previously granted limited leave to enter or remain. So that is the key point for immigration rules. All right. So let me go to discussion. So a father or a mother who came in the UK under EU settlement scheme, or even it is applicable for future as well, came in the UK, get the family permit under EU settlement scheme, and once they are in the UK, not only parents of EU nationals, not halal bhai, it's not only your parents, your father-in-law, mother-in-law as well. So your wife is non-EU national, their parents as well, under the same rules. So, so there are some misunderstanding. People think that Brexit there is no more EU family law. This is not correct. Still is applicable under EU settlement scheme, family permit, same law. So still you can bring your parents or mother-in-law, father-in-law. Anyway, so so if your parents come in the UK under EU settlement, they got the family permit 6 months. Once they're in the UK, they will apply for what is called pre-settled status. So under immigration rule C, they do not need to be meet the requirement of dependency because they get leave to enter or leave to remain in the UK under Appendix EU. So when I refer the judge, I make submission only 2 to 4 minutes. And if you look into my Google review, the client has given a review exactly the same wording. She said only 4 minutes my submission was. So I tell the judge, if you look in the first line of paragraph B, and then I refer paragraph C of the Roman A, said that there is no requirement to dependency if the applicant enter or get limited to leave or limited leave to enter under Appendix EU. So as my client has received family permit under EU settlement scheme, so under Immigration Rules Appendix EU C, he has limited leave to enter, therefore he doesn't need to be prove dependency. So what I am saying here, exactly the same wording I said, and judge in open court tell the Home Office caseworker, do you have anything to say? So Home Office worker still arguing this be applicable, but judge was bit, he was not happy about the Home Office caseworker's submission, because the immigration rules is very clear, and that the judge's commission in the open court judge allowed the appeal. So that's what for today only, just one question, and although it's only one issue I discussed, but the impact is huge, because many people applying for pre-settled status for their parents, unfortunately, because the caseworker misunderstood the immigration law. And what was surprise to me, during the hearing, the Home Office lawyer took 2 breaks to get advice from her senior lawyer, senior supervisor, senior caseworker, and 2 times she got out from the courtroom, court adjourned for 10 minutes, 15 minutes, and she still has not changed her position or clear what is the correct law, which paragraph should apply on the relevant issue, whether someone has to be dependent or not. So that's why I said the Home Office lawyer even not understand or clear immigration rules, how the anti-clearance officer or a caseworker would know what is the correct law is. So if your application refused, or if your parent's application refused, I think you should consult with a lawyer who are familiar with this, and then get the right advice, do the appeal. You have a good chance. Good luck everyone for today, and I hope you this information will help you and hereby thank you, all of you. And I will do a long live session tomorrow, and I'll take all the question to give you answer on Facebook. Hopefully this weekend, 3 days long, and then I'll do a couple of sessions. So if you have any question, please feel free to message me. I'll give you answer on my next live.